Hello, good people. Welcome to the Charter Rights Enthusiast channel. On this channel, I'll be posting about Canadian civil rights while filming in public. Because filming in public is a civil right. It's an exercise of freedom of expression, one of the fundamental freedoms protected by Section 2 of the Charter of Rights and Freedoms. One of the reasons why I'm starting this channel is because for a while now, I have been watching police-civilian interaction videos online on YouTube, and as you might imagine, most of these videos come from the United States. So while I was learning a lot about civil rights in the United States, I realized I knew very little about my Canadian civil rights. So I decided to investigate, and I discovered a trove of interesting information, and I thought it would be fun and of socially redeeming value to share this information more widely. Now today we're on Bait Island, which is in the Remick Rapids in the Ottawa River. As you can see, there's a bridge. And by sheer coincidence, there is a police encounter going on right here. So this gives me an opportunity to tell you about the second reason why I'm starting this channel. That is to encourage people to record police whenever you see them out in public performing their duties. We have this right, as I will explain further later on in the video. Now, I'm not a lawyer, that should be clear by now, and as such, I do not give legal advice. If you believe yourself to be in legal jeopardy, don't rely on anything I say here. I guarantee nothing. No correctness. So, talk to an attorney. They're the experts in the law. You can always do this. It's one of your civil rights. While I was watching these videos, I came to a realization. This is going to sound pretty naive to anybody whose life has brought them into close contact with the police and the criminal justice system, but if you, like me, are a person who's not been brought into close contact with the criminal justice system, then you may not have thought of it so explicitly in these terms. If the cops want to, I realized, they can make your life difficult, possibly ticket you or even arrest you if they want. And it's not that every cop is going to do this, but it's that they can. Why would they? Maybe you've annoyed them by using your freedom of expression in a manner which doesn't give them the respect they feel they deserve. Maybe they just had a bad day. Maybe they've been ground down by the job. And maybe they were always a bully by nature. Regardless, if they arrest you and charge you, then you are in for a bad time. You have, in Canada, one of three bad options. You can either try to defend yourself. This is called being a pro se defendant. And if your case is at all complicated, you'll probably lose. Or you can hire a criminal defense attorney for a lot of money. Or if you don't have a lot of money, you can seek out legal aid. No matter what, you're in for a bad time. Now, they can't do this completely arbitrarily. There's a standard they have to meet. In Canada, it's called reasonable grounds, or reasonable and probable grounds for making an arrest. And while it's not nothing, it's not too hard to meet. We're just going to pause here and watch what's going on. let's continue. You'll be in for a bad time, as I was saying.
Yeah, then you got a second card there.
And now I'm distracted again.
Stay with him, Matt.
Yeah, just one different.
No, it's fine. You can stay in the car.
Okay. That's good. Want us to just send it to you later, kind of
Oh,
thing?
yeah.
Yeah,
Oh,
okay.
yeah.
Mark for you?
Just like we've always done.
Yeah, it's just a little statement.
Yeah.
Fair enough.
Anyway, like I was saying, you're in for a bad time. And this is the way the system works. By design, I think. We get the presumption of innocence, and in return, the standard for making an arrest is not that high, and the criminal justice system sweeps up people who the Crown may never have a chance of convicting, and some people who may actually be innocent. So, maybe this would be a tolerable state of affairs if we could trust police officers to exercise their powers of arrest with detachment and keen judgment. But can we? Not every officer, that's for sure. An example will be forthcoming. The problem is with the culture of policing. People aren't special. The police aren't special. They're just people like you and me. Some are good, some bad. Some excellent, some execrable. And in terms of the culture, for me, I think it really boils down to two issues. First, even better than average cops will, in some situations, defend and protect the actions of bad cops. Not always. Not every cop. But enough. The second problem is that some police officers feel entitled to commit perjury, to lie on their sworn testimony and sworn statements, either by omitting exculpatory evidence, or by exaggerating inculpatory evidence, or sometimes by out-and-out fabrication, to the point where any criminal defense attorney is well advised to assume that the police are going to lie. They call it testi-lying. I don't think change is going to come from within the culture of policing. And politically, the institution of policing is so powerful that civilian oversight has trouble reining it in and providing actual oversight. So I think the best thing that we, the policed, can do is anytime we see the police out performing their duties in public, take out a camera and record. We can always do this. We have a right to do it. This right was affirmed in a sentencing judgment in the case of Crown versus Zarafonitis. Now, I'm a little bit unsure about how Canadian cases are supposed to be referred to verbally. I think maybe it's supposed to be the Crown and Zarafonitis. But it's always written, versus. So that's how I'm going to say it. And if I've got this wrong, please correct me in the comments. Anyway, The details of this case are as follows. Constable Paul Zarafonitis was called to a noise complaint in Niagara. He's a constable in the Niagara Police Service. He was called to a noise complaint at a bar late at night. And the problem had been a recurring one. And in this particular instance, this bar was hosting a rap competition. And so the police came in and they ejected the rappers out onto the sidewalk. And they were followed out by the bar patrons, who were basically a drunk, angry mob. They were also followed outside by a man that the venue had hired to photograph the event, whose name was Mr. Farkas. I've forgotten his first name. Doesn't matter. Mr. Farkas started taking photographs of the scene out on the sidewalk, and Constable Zarafonitis told him to stop taking pictures and to leave. And Mr. Farkas declined. So Constable Zarafonitis, who outweighed Farkas by nearly 100 pounds, socked him in the face and broke his orbital socket. That is a common injury when a person is punched in the face in earnest, and arrested him for drunkenness. Constable Zarafonitis was himself charged with assault causing bodily harm, and he pled guilty, was given a suspended sentence, a year of probation, 40 hours of community service, and he had to pay a $50 victim surcharge, which goes into a fund for the victims of crime in this province. Alright, great. So the system worked, kind of. Man who committed a crime
So
was
good news,
charged.
bad news.
Okay.
Let's hold on here.
So I called the boss, and the suspend driver video bring the gentleman over here. Oh, we got good news. Right over here, buddy. So,
Oh, I can't hear anything. I'm not going to try to approach closer. Not really what I came out here to do. Just a happy coincidence. Anyway. I don't plan on reading directly from a lot of court judgments and opinions. That is too in-depth and kind of boring. But in this case, I will, because what the judge wrote in the sentencing opinion is deeply influenced from my perspective, and is in fact a large part of why I decided to start this channel. Here's the judge writing. I am faced with the rather peculiar situation where Mr. Zarafonitis was faced with a loud and aggressive assembly, but instead chose to focus his substantial legal and physical power and authority on the person who was taking photographs of the police-citizen interaction. I I obviously cannot read Mr. Zarafonitis' mind, but his focus on Mr. Farkas in light of the picture painted for me by the agreed statement of facts reflects an odd sense of priorities. Mr. Farkas was not arrested for obstructing police, or for breach of the peace, or for causing a disturbance, but for the rather minor provincial offense of being intoxicated. His arrest was preceded
So
by...
I've got his driver's license and his vehicle documents, okay?
His arrest was preceded by a direction by Mr. Zarafonitis to move away, which may or may not have been lawful, and a direction to stop photographing, which on the facts before me had no lawful basis. That latter direction, therefore, was another occasion that night when Mr. Zarafonitis overstepped his powers. I'm going to skip a couple of sentences here. And picking up again. In the absence of an overarching and tangible safety concern, such as telling the photographer at a fire scene to back away if there's a danger that a building will collapse on him, telling people not to record these interactions, whether they be a bystander or the person the police are dealing with, is not a lawful exercise of power. An officer who conducts himself reasonably has nothing to fear from an audio, video, or photographic record of his interaction with the public. The public has a right to use means at their disposal to record their interactions with the police, something that many police services themselves do through in-car cameras and similar technology. The officer's powers exist to allow him to protect the public and himself and to enforce the law. They do not extend to controlling the public record of what happens.
It has to go to another property. Another property?
The maintenance of that public record plays a significant role in the maintenance of the rule of law. The existence of this form of objective oversight has great potential to minimize abuses of authority and to maintain peaceable interaction between police and the citizenry, all of which is very much in the public interest. Interference by a police officer in the public's exercise of that right is a significant abuse of authority. Okay, so this isn't binding precedent. This is what lawyers who love their legal Latin call obiter dictum, things said by the way. This is a sentencing opinion. The judge doesn't have to put a diatribe about the right to record police in the middle of it. So it is significant that the judge chose to do so anyway. It is a strong rebuke to the defendant, Constable Zarafonitis, and a message to all police in general. It's also worthy of note that the judge also mentioned audio and video recording in addition to photography, given that the events in question only involved photography. That was an addition as well. That was quite deliberate. So my other goal in starting this channel is to spread this message. Almost all of us are carrying cameras in our pockets. So, when you can, if you see the police, record them. If you see a police car parked illegally, record. If you see police managing the scene of an accident, record. And if you see the police questioning someone, definitely record. Even if you're recording an event where police misconduct is unlikely, normalizing recording will instill in police the sense that they could be recorded at any time, and the mere anticipation of scrutiny will help maintain professional standards and respect for our civil rights. If you enjoyed the video, hit the like button, and if you like learning about Canadian civil rights, hit the subscribe button. And remember, if you see the police out on the street, record, record, record. Like I'm doing right now.